Hey everybody, News Now Wyoming, bringing you the second episode of today. This is going to be a letter that I wrote to our Wyoming legislators, asking for them to fix the mistakes I found in the law. This is for the Bryant Vs the Stupid deputies case. And basically, I've got to agree that the judge read the law correctly. So what do you do when you find a bad law? You ask for them to fix it. Not for the court to fix it. That is not their job. The court's job is to rule on the law. It's the legislature's job to fix the law. So I've written this letter to the Joint Judicial Committee. This is both of our houses here in Wyoming combined. They've got a Joint Judicial Committee where they meet throughout the year on different resolutions. So that is who I've directed this to, and it's who I'm going to be sending this to after I date it and put my name at the bottom and all that stuff. But I want to share it with you guys before I finished it all up. See what you guys think, and also maybe give you some ideas. Again, if you live here in Wyoming and you have problems with the same law I do, maybe you disagree with me. Let me know below. Why do you disagree with my letter? I write to you today with concerns that I have about a law the legislature's passed, hoping to get the wrongs discussed corrected. In this letter, I will discuss what the law currently states, provide an example of a case where the law was applied, and also how I think the law should read. In 1979, the statute of limitations for suing governmental entities for intentional harm was written and passed as below. And here it does provide the entire law, but unless commenced within 1 year after the date is claimed pursuant to 139.113. And then it's got exceptions for minors and etc., not applicable. The ability to sue for negligence or unintentional harm is covered in statute 13105 within 4 years an action for an injury to the rights of the plaintiff not arising on contract and not herein enumerated. So basically, that's the negligence claim. If you were suing for negligence, you would be suing under negligence. So it continues in AVB that being able to sue for assault and battery has a statute of limitations of 1 year. You know what? Give me 1 second. I'm going to add one. Okay, I also wanted to add this D. In AVD, it states that if there is a further statute that is provided, that statute should be used instead. Upon statute for a penalty or forfeiture, except that is a different limitation is prescribed by the statute in which the remedy is given, the action shall be brought within the period described by the statute. So basically what I'm saying with that is this 39114 reads different. So if it's against a governmental body, then we shouldn't take into account what it says for assault and battery. In the Federal District Court of Wyoming case Devin Bryant versus Ryan Lee, Jason Gillett, and Laramie County Commissioners, and I give the case number, the court rightly decided that Wyoming statute does not allow an individual to sue for intentional assault and battery after 1 year has passed, but if it were negligent behavior, the case could continue. It is my belief that intentional harm by a governmental employee is worse than negligent harm and should have a higher statute of limitations to demonstrate that. In the case of Bryant versus Ryan Lee et al., the deputies arrived at his house in the early morning hours, 2:45 a.m. of January 28, 2020, after receiving word 9 hours prior that Mr. Bryant had threatened self-harm. Video camera evidence from the body camera worn by the deputies show that after refusing to show the deputies his arms, they suddenly reached into his house to pull him out and entered the house to remove him without warning. The videos continue to show one of the deputies tasing Mr. Bryant's mother and Mr. Bryant while he was restrained by the other deputy. The officers then arrested Mr. Bryant and his mother for resisting arrest, which was dismissed by the courts later. Before they attacked Mr. Bryant and during the ensuing fight for control, the video never shows the deputies tell Mr. Bryant he was being detained or arrested. The deputies that were concerned for Mr. Bryant's safety also never brought him to the hospital for mental evaluation, their entire premise for being on the property. I do believe that it is this type of behavior of governmental employees that convinced the 1979 legislatures to pass a law removing immunity from those government employees and their employers who act in harmful ways. I find it deplorable that had this been an accident instead of intentional, the case would still be moving forward on all 4 counts. I am asking that the Joint Judicial Committee bring forward a resolution changing the statute of limitations listed in 1-39-114. Is that correct? Yep. To 4 years. Thank you for your consideration. Then it'll have my name and stuff. And then I will also... I am also attaching the PDF with the court case for your reference. Court case opinion for your reference. Alright, so what do you guys think there? Should I add anything else, or do you think it's good the way it is? Will it work? Will they actually do anything? I doubt it. It's Wyoming. And we are so pro-police state. But hopefully it'll touch somebody, and somebody will be like, yes, I agree, this is wrong. So let me know what you guys think. Let me know your comments below. Make sure you hit that like and subscribe if you like the content. Thank you very much.